Hello and welcome to LawPutra YouTube channel. My name is Ananya Singh and today I will be discussing with you the difference between lease and licenses. We get to hear about lease and licenses on an everyday basis, but still we do not know the exact difference between the two, or we are confused about the difference between the two concepts. So today we will clear all those confusions by learning about each of them. There are different laws that define lease and licenses. For example, lease is defined by Transfer of Property Act 1882. On the other hand, license is defined under Indian Easements Act 1882. But before we jump to the legal provisions, we need to first understand the meaning of these terms, lease and license, in the common parlance. So, lease can be defined as the right to enjoy an immovable property, and that is for a certain period of time. And it has to be done in consideration of a price paid by the person who gets the possession of the property. So, basically, it is a contract under which an owner of the property grants another person exclusive possessory rights of the property and for an exclusive possession of that property, and that is done for an agreed period between the two. Also, it has to be done in return for a rent or payment or a capital sum which is known as premium. So, rent could be monthly rent or yearly rent. A premium, however, could be from any term. For example, a premium could be for 2 years, 3 years, or 5 years and specified amount of sum. So, license is basically a permission to enter or occupy a person's land for an agreed purpose. However, the case is not the same with lease. Now, when we talk about licenses in context of property law, it would mean to have an authority to do a particular act or series of acts upon another person's land without possessing any estate therein or any interest in that property. It is basically a permission to enter or occupy a person's land for an agreed purpose. Section 105 of Transfer of Property Act defines the term lease. It states that a lease of immovable property is a right to enjoy such property. Now, it is clear with this that the lease can only be made for an immovable property and never of a movable property. It further states that it is made for a certain time. As I have stated earlier, it has to be made for a particular period of time only for it to be leased. Otherwise, it would be sale. If it is transferred for forever, it will convert into sale. It will not be a lease. So, for it to be qualified as lease, it has to be done for a certain period of time. Section 105 further states that it can be express, implied, or in perpetuity. Express meaning it will be written clearly that it is that, or it can be implied like it is derived from the consequences or the facts, or it can be in perpetuity. In perpetuity would mean for an indefinite period, and it has to be in consideration of a price paid or promised or of money or a share of crops, service, or any other thing of value. So, what matters is not the nature of consideration here, but the presence of a consideration in a lease. It also states that the value or the consideration has to be rendered periodically on specified occasions to the transferor, meaning the person that transfers, by the transferee, meaning the person in whose name the lease has been assigned, who accepts the transfer on such terms. Now, if we see who accepts the transfer on such terms, it sort of seems like the concept of consensus ad idem, meaning the meeting of minds of the parties at the time of the contract. Now, with regards licenses, it is section 52 of the Easement Act 1882 that defines license. Looking at the definition of the license, we will see that it states where one person grants to another or to a definite number of other persons. It means that a license can be given to one or to many other people. A right to do or continue to do in or upon the immovable property of the grantor. What has to be seen that the property has to be immovable here as well, as we have seen in the case of lease, and it has to belong to the grantor or the person who is granting the license to the person. It further states that something which would, in the absence of such right, be unlawful, meaning the act that is being done by the licensee would be unlawful to be done on that person's property had he not been in possession or been granted that particular license. For example, if a person gives me a right to sow their field, so if I do not have that license to sow their field, it would amount to trespass, so it would be unlawful in that sense. It also states that such right does not amount to an easement or an interest in the property. That right is called the license. So the interest is not created in a license. However, it is not the case with leases. So looking at the meaning of licenses and leases, the terms look very similar, but there are some key points or features that distinguish between the two. Let's look at that one by one. So when you talk about a lease, the transfer of interest is done in specific immovable property. But in a license, it is not transferred. The interest is not transferred, but it is just a permission to exercise a right upon the property for a limited period of time, or it could be for any amount of time as specified in the license. Another key difference between the two is that lease does not come to an end after the death of the lessor or the lessee. As we have seen earlier, that lease is an inheritable right. So even after the death of any of the two parties, the LRs, meaning the legal representatives of any of the parties, can continue with the lease. But license comes to an end with the death of either of the two parties. For a lease to come to an end, the certain conditions that have been stipulated in the terms and conditions of the contract will have to be fulfilled or to be complied with. But the license can be withdrawn at any time at the pleasure of the grantor. Another thing we will look at is that when the property is leased and is sold to a third party, it remains unaffected. It means that the rights of the lessor are not affected by that. The lease continues and the purchaser of the property has to wait till the period of the lease for which it was leased has been finally terminated or is expired. However, license comes to an end in case the property is sold to a third party. A lessee has a right to protect possession in his own right, meaning he can protect his possession by even filing a suit against the owner. But a licensee cannot defend his possession in his own title because he does not have any proprietary right in the said property. A lessee would be entitled to any improvements that are made to the property, but a licensee will not hold any rights over the improvements of the property. And with that, I would like to conclude this session. Thank you so much for watching LawPutra. Hope it was helpful for you. See you again. Bye.